Welcome to the Shaftesbury Society, the weekly meeting of the John Locke Foundation. My name is Mitch Kokai, and thank you for joining us once again for this discussion. It's going to be a very interesting discussion about an issue, voter ID, that has faced a number of legal challenges. We're going to be focusing most specifically on the piece of the legal challenge that has gone all the way to the U.S. Supreme Court. And the guests that we have with us today will talk about that particular piece of the story in just a few moments. Before we get into today's program, though, I do want to let you know about a major development for the Shaftesbury Society meetings going forward. Those of you who've been following us for more than a couple of years know that prior to the beginning of the COVID-19 shutdowns, the Shaftesbury Society was an in-person event. It took place every week at the offices of the John Locke Foundation. And because of COVID, we shut down those meetings, transitioned them into this Shaftesbury, it was called at the time Shaftesbury in Place, where you'd have the host sitting in this spot and the rest of the panelists involved in the discussion joining us via Zoom. Well, we've enjoyed doing that. We've had a lot of lively and very good discussions. We expect another good one this time around. But starting in 2 weeks from today, we're going to resume the in-person Shaftesbury discussions. So if you follow the John Locke Foundation and follow the Shaftesbury discussions, follow where you normally do, you'll get the information about the first in-person event of the resumed in-person Shaftesbury's. That'll be taking place on April 18th. We look forward to that. We look forward to seeing some of you join us for those discussions in person. We look forward to seeing you once again. And we will welcome the return to another piece of life post-COVID scare, and that is the return of the in-person Shaftesbury Society meetings. Looking forward to that. But we are also looking forward to this very good discussion, and the format that we are using today makes a discussion like this possible because we have three guests, two of them joining us from the Washington, D.C. area, the other from Florida, and that is a discussion of the issue of voter ID. North Carolina voters agreed to add a voter ID requirement to the state constitution back in 2018. Shortly after that vote in November 2018, state lawmakers approved a law to implement the voter ID constitutional provision. Yet more than 3 years later, this state still has no voter ID requirement in place. Why? Well, that is the subject of today's Shaftesbury Society discussion. My colleague, Dr. Andy Jackson, director of the Civitas Center for Public Integrity, is going to join us to talk about the voter ID law itself. And then we'll also hear from representatives of three national groups. Each of them filed briefs with the U.S. Supreme Court, and they're supporting state legislative leaders' efforts to play a role in defending voter ID against a federal lawsuit. We're going to hear from Jason Sneed of the Honest Elections Project, Tom Spencer of the Lawyers Democracy Fund, and Jonathan Howenschild of the American Legislative Exchange Council, or ALEC. So we welcome all of you to the program. First, I'm going to turn it over to my colleague, Andy Jackson. And Andy, I think when most people think about voter ID, they think you go to vote, you pull out your driver's license, you hand it over, they look at your license, look at you, decide that you're the person who's on the license, and give you the ballot. Voter ID and the types of IDs and the way that this would work out is actually more complicated than that. Tell us a little bit about this voter ID law that was passed in 2018.
Right, and there's a couple things. As you already mentioned, the constitutional amendment that requires voter ID was passed 55% to 45% in 2018, followed by enabling legislation that was passed a month later. And Governor Roy Cooper, vetoed it. The General Assembly, which had a Republican supermajority at the time, was able to override that veto. And also since then, we've had a couple of changes to that law. So we've had a law that we haven't been able to implement in North Carolina, yet the General Assembly has been able to do a couple of changes, and they were largely bipartisan. One was a technical corrections bill that modified some forms of student IDs that were allowed and other things. And also there was another bill as part of a bipartisan elections compromise passed in 2020 that included further modifications to the bill. And I'm just going to quickly go through the list of IDs that are allowed under this law. First one, of course, is the North Carolina driver's license. We have non-driver's license IDs issued by the Department of Motor Vehicles, United States passport. There's free voter IDs issued by county boards of elections. That is required by the law. So if you don't have money to get an ID, you can get a free one from the county board of elections. Student ID cards, either from a UNC systems school or community college or a private university or college, as long as they follow certain standards on issuing those IDs. Employee identification cards issued by county governments, including schools and charter schools. A driver's license from another state, as long as it's as long as you've registered less than 90 days before, because it has to be still valid. Also, we have, and all of those are IDs that you need to have valid right now. So you can't have an expired license, for example. In addition, there are certain classes of IDs that they will accept even if they are not currently valid, if they're out of date. And those include military identification cards, veterans identification cards, tribal enrollment cards, Cherokee, Lumbee Indians, for example, and also public assistance cards, welfare cards, if you will. Although you can put an asterisk on that because the federal government currently doesn't put pictures on those cards, but if they started to do so, you could use that as an ID to vote. There's also a lot of provisions about what to do with, for whatever reason, you can't get an ID. For example, if you have a religious objection to getting photographed, if for some reason you can't get a hold of an ID for lack of transportation, you don't, you're ill, you don't have a birth certificate to get one, or if your ID is stolen, any number of those reasons, you can still go and vote. And what you would do is fill an affidavit, and that ballot would be a provisional ballot. And unless the county board of elections has some good grounds to believe that your affidavit was not legitimate, they'll accept it. So there's kind of that backdoor way to get in, to get your ballot counted, even if you don't have an ID for whatever reason. Also, if you are living in an area of a natural disaster, say a hurricane comes in and a natural disaster is declared in your area, and this happens a lot in North Carolina, in those affected counties, you could also sign an affidavit and vote without an ID. The last interesting thing I want to note is that this is one of 3 cases that we're dealing with on the voter ID issue. And by the way, this is just for in-person voting. There's a separate law for IDs for absentee voting that's not affected by these. We have the federal case, which we're going to hear about today. We have a state case against the implementation law. And this, as far as I have heard, is unique. We actually have a case where they may declare part of the North Carolina Constitution unconstitutional because they objected to the way it was added to the Constitution. That's a little outside the box for our discussion today, but that's the case that the North Carolina Supreme Court just heard, and we should be hearing later this year their ruling on.
Glad you referenced that, Andy, because that is something we're going to get to before we turn it over to our other guests. But I want to ask you, as someone who has followed voter ID very closely for a number of years, you ran out of fingers when you were doing the different types of IDs that could be counted. It's safe to say that this voter ID law is very open to voters voting, more so than some voter ID laws that have been held to be constitutional in other states. Is that correct? We have one of the more permissive voter ID laws.
Yeah, the federal courts have already upheld similar voter ID laws, particularly the one in South Carolina. Part of the reasons that we've run into this problem is that an earlier version of a North Carolina ID law was struck down. This was after they passed a kind of omnibus election law in 2013. That was struck down in federal court, and the district judge in this case, Judge Briggs, ruled that partially as a result of many of the same legislatures that passed the previous law were still in the General Assembly when this law was passed, the kind of presumption of that the General Assembly was doing this in good faith, she said, well, we're not going to have that presumption here. So even though very similar laws were upheld in federal court in South Carolina, because of basically this judge's dislike of the General Assembly members, she ruled that they were not going to allow this North Carolina IB law.
Well, it's a very interesting development, and that was a great recap from my colleague, Dr. Andy Jackson, who is the director of the Civitas Center for Public Integrity, focusing on this issue quite a bit, along with a lot of other election-related issues. And as a reminder, as Andy said, 3 different lawsuits that have been challenging voter ID. Right now, and Andy, you can jump in and correct me if I'm wrong, but I believe right now, the suit that is blocking voter ID is the state-level suit. There was a 2-1 ruling from a Superior Court panel that threw out voter ID. That case is now in front of the state Supreme Court. Both sides are doing the briefing. We have yet to have oral arguments in that case, but our state Supreme Court will be hearing arguments and then eventually reaching a decision on the 2018 voter ID law. As Andy mentioned, there is also a case that's challenging the 2018 constitutional amendment for voter ID and that could possibly strike that amendment from the ballot. The state Supreme Court heard oral arguments in that case on February 14th, and we are awaiting a ruling from the state Supreme Court in that case. And then there's the third case, and that's where we're going to bring in our other experts on our panel today. The third case is the federal lawsuit against voter ID. Initially, Judge Briggs, Judge Briggs, or is it Judge Biggs? Loretta Biggs or Briggs? I'm losing it at this point. The judge in the North Carolina court, federal court, initially placed an injunction against the voter ID law. The Fourth U.S. Circuit Court of Appeals came along about a year later and removed that injunction. That case is at some point supposed to go to trial before the judge in the federal court in North Carolina, but in the meantime, our legislative leaders who have not been allowed to participate in the federal case went all the way to the U.S. Supreme Court to try to get permission to represent some of the state's interests in defending voter ID at the federal court level. That is why the case got to the Supreme Court, and that is why each of our other guests on the panel is involved in this discussion today, because each of their groups filed an amicus or friend of the court brief to the Supreme Court supporting the legislators' ideas of trying to get involved in defending voter ID as this case proceeds in a federal trial. So we're going to bring in now each of our additional panelists to talk about a little bit about what their group is, why they decided they were interested in this case, and what they hope the U.S. Supreme Court will consider as it makes its decision. Let's start with Jason Sneed, who is with the group, the Honest Elections Project. Jason, first of all, tell us, what is the Honest Elections Project and why were you interested in this case coming out of North Carolina?
Well, I'd be happy to. And first of all, let me extend my thanks for the invitation and for this program. I'm really looking forward to the discussion today. So the Honest Elections Project is an organization which we set up about 2.5 years ago to focus on ensuring that we have elections that are governed by fair and impartial election laws that are established through the proper channels, that are in place before an election begins and are in effect through the end of voting, and laws that ensure not just adequate access to the ballot box, but also security for the ballot box. And so we became particularly interested in this case because it implicates all of those issues which are core to our organization's mission. You know, as I said, we want fair laws. And part of that fairness stems from the fact that you have to provide for ballot security. And voter identification laws are one of the most fundamental best practices, which we recommend that every state adopt. They're also one of the most contentious politically and are always under attack in the courts. So we're very eager to find any opportunity that we can to ensure that these laws are getting properly defended and that we're getting good case law out of the federal and state courts. You know, we also want laws to be passed by lawmakers. That is why we call them that. We don't want executive branch officials or courts to impose or undermine law or simply change public policy because they have personal disagreements with a law that is passed by the democratic process. And we want to defend the US Constitution's clear delegation of authority in election cases to state legislatures to establish the times, places, and manners for conducting federal elections. There are two provisions in the US Constitution, the Elections Clause and the Electors Clause, which, depending on the precise language here, give the power to state legislatures to be the principal actors, either in setting the provisions for determining the rules for congressional elections or determining the appointment process for presidential electors. In this case, deals with the Elections Clause issue and that question of federal constitutional delegation. So, we generally believe that, the number one goal for any of our groups engaged in this public policy space, for lawmakers and everyone, should be to ensure that we are bolstering public confidence in the integrity and the reliability of elections, because that not only breeds legitimacy in government, but it also encourages turnout and participation. What we're seeing right now, I think, just to kind of step back from this case for a second, is that public confidence in elections themselves is waning. And this is something which affects both the left and the right. Part of that is that election rules themselves have become contentious and have become the target of political attacks. And I think that we've all heard the debate that's been raging over the last year or so, with allegations that any law that does not exclusively focus on public access, but even one iota deals with public confidence or public security, that these are branded as voter suppression and treated as policies which are indeed adopted specifically to prevent people from voting. And voter ID is one of the most common targets for these sorts of attacks. Well, when you attack the laws that actually bring transparency, accountability, and protection to the ballot box, I think you're inviting the public to lose confidence in the process. And activists in particular are always looking for ways, for opportunities to weaken or eliminate ballot security. Unfortunately, and this is where we'll turn back to the case in question here, activists and many public officials increasingly view the courts as an extension of the legislative process, as just another organ of government responsible for making law and making public policy. And sometimes attorneys general, who are after all supposed to defend the law when it is challenged in court, sometimes they welcome or even invite litigation because it creates opportunities for them to change policies which they may personally disagree with, or which will help them to advance a personal or political cause. Well, when that happens, laws that are adopted through the democratic process, which are adopted through the legislative process, are not only not properly defended, but they can in fact be undermined, rewritten, or waved away in closed-door negotiations between attorneys general and friendly activists, or by courts and judges who have personal objections to a law. I would argue that when such events happen, you are setting the stage for the public to lose confidence in an election, particularly the side which loses that election, because after all, you are then changing the rules, sometimes in the middle of voting. And I don't think that is the way that most people would perceive fair elections to be run. Unfortunately, this is something which has happened increasingly over the last few years. In fact, in 2020, before Election Day, there were more than 200 lawsuits filed to change election rules. And in many of these cases, attorneys general moved to either settle these cases, to enter into consent decrees, to change or to change rules in the election process, or they simply offered lackadaisical legal defenses, essentially fumbling these cases so that their political allies could win. So we wanted to get involved in this case because it's one of the clear opportunities for us to assert that central elections clause principle, that the state legislature is the key actor for establishing election rules and election procedures, and that they have a clear interest in making sure that those laws are defended and that voters writ large have that interest as well. So with that, I'm looking forward to the discussion, looking forward to hearing from the other panelists.
You've been hearing from Jason Sneed. He is Executive Director of the Honest Elections Project, a group that filed a friend of the court brief in this case at the U.S. Supreme Court. Another group that filed an amicus or friend of the court brief at the U.S. Supreme Court, the Lawyers Democracy Fund, and its vice president is Tom Spencer. And Tom, if you'll tell us a little bit about your group and why you decided to get involved.
I certainly will, and thank you again for the opportunity. I thought that Jason's statement was not only articulate, but also covered exactly what the Lawyers Democracy Fund is all about. All of us are very experienced election lawyers. We've been in the trenches for decades. We've litigated vote fraud cases throughout the country. We've engaged in appellate work in connection with elections. We are election integrity zealots. We believe in honest elections. We want elections which make it easy to vote and almost impossible to cheat. And therefore, as we have gone through the cases that have challenged that principle, we have engaged in amicus briefs. We have acted as resources for journalists, for legislators, for members of Congress, members of the Senate. We have opened an entire library of various cases and litigation pleadings and made them available. Locke Foundation has done an absolutely fantastic job in that connection, and I'm particularly taken and was taken in preparing for this by Dr. Jackson's very, very well done memorandum on litigation involved in and the Mark Elias type approaches to collusive litigation. I thought it was really well done. I hope that people who are interested in this area will get a copy of it and read it, because it really covers the waterfront. We got involved in this case, not only in this Supreme Court case, but also in the state court case, because we see this as this matter and this problem as a shining example of how legislators have been chiseled away from their rightful place in connection with election law. I myself was counsel in the Bush versus Gore litigation. I've tried a lot of election fraud cases throughout the United States, but also in Florida. I've seen how people have engaged in election fraud and how courts have attempted to take the wheel of justice away from the legislature and use it themselves in order to make a policy decision. Our Florida legislature attempted to do that in Bush versus Gore. And there are courts throughout the United States which are engaged in the same type of activity. From my perspective, the relationship between the states and the federal government, as articulated in Article 1, Section 4, demonstrate that the legislature, the branch of the government closest to the people, is the one designed and recognized by the founders to be the one that the branch which actually transmits election laws, and we've got to protect that. So that essentially is where we stand. What we would like to see come from this case, and I think it will happen, is that the court will articulate and reaffirm a rule that the legislature, in connection with election laws, has a primary and important interest in this litigation and in similar litigation when presented to courts. And therefore, a lot of the confusion concerning intervention by legislators will dissipate.
That is Tom Spencer with the Lawyers Democracy Fund, Vice President there, another group that has filed a friend of the court brief, in this case at the U.S. Supreme Court. And a third brief came from the American Legislative Exchange Council, as we here in the Locke Foundation know as ALEC. And joining us from ALEC to talk about that group's involvement is Jonathan Hauenschild. And Jonathan, my guess is, and correct me if I'm wrong, one of the reasons ALEC wants to get involved in this is legislators defending their right to play this major role in the legislative process and defense of it.
That's absolutely right. So for those who are not familiar with ALEC, we are the nation's largest bipartisan voluntary membership association for state legislators. Obviously, that's a little bit of a mouthful. Essentially, what that means is we're somewhere between a trade association for state legislators that would like to advance principles of federalism, free markets, and limited government, and a forum for the actual exchange of those ideas. We did get involved in the case, in large part combining some of the logic and the reasoning and the explanation from both Jason and Thomas. We have seen over the past few years, the courts essentially diminish the role of the state legislators in both protecting their constitutionality of their laws, as well as their role in the state election process. That was no more evident than in 2020, where we saw bureaucrats and attorneys kind of collude to change election law on the fly in states like Georgia, North Carolina, Pennsylvania, and even Michigan, and even attempts in Wisconsin. But ALEC has a long history of actually intervening in these kind of cases as a party, a friend of the court, to explain the role of the state legislature. And what we particularly saw in this case, coming out of the Fourth Circuit, was a decision to ignore validly enacted state law. So North Carolina has a law that says when the constitutionality of a state law is challenged, it is the responsibility of the legislature, through the Speaker of the House and the President of the Senate pro tempore, to determine whether the legislature or the Attorney General will represent the interests of the legislature or of the state, not just the legislature, the state in court. And the Fourth Circuit essentially decided to ignore that law. What we saw was the Fourth Circuit say, hey, the Attorney General's involved. The Attorney General traditionally and historically represents the state. And as long as it plausibly and provides a decent defense for the state and will determine what that looks like, the Attorney General is the appropriate party. So we saw the Fourth Circuit ignore validly enacted state law. And that's where we kind of had to step in and say, well, if you're going to do that, how many other provisions, whether it's US Constitution, Article 1, Section 4, or other state laws, are you going to ignore? And that's what we kind of tried to present to the US Supreme Court, was that perspective of 50 state legislators and come in and say historically, hey, the legislature has the right to pass its own laws explaining who should represent it in court.
Thank you, Jonathan Hauenschild with the American Legislative Exchange Council. We've now heard from each of our panelists at one point, and we're going to welcome all of them back into the discussion during the rest of the course of this hour. A couple of things before we move forward. One, I want to apologize to Judge Loretta Biggs. I didn't mean to call her Briggs earlier. She is a federal judge who will be hearing this voter ID case once the U.S. Supreme Court decides whether the legislature can intervene. The other thing I want to mention is that if you're watching this presentation on the John Locke Foundation's Facebook page, facebook.com/John Locke Foundation, please feel free to submit any questions you have for the panelists, either our own Dr. Andy Jackson or the panelists from the Honest Elections Project, Lawyers Democracy Fund, or ALEC. We will be certain to pass along questions to them that would help enlighten you on this subject. I want to loop Andy back into this discussion now because we had one of our panelists, Andy, make reference to the work that you've done on collusive settlements involving our state attorney general. And I suspect that in this case, one of the reasons the General Assembly and legislative leaders want to be involved in defending voter ID is concern, their historical concern about collusive settlements. Tell us a little bit about your work on that topic.
Well, yeah, this was actually the first piece I wrote when I came on board with the John Locke Foundation from the Civitas Institute. So I'm glad people are still reading it. That makes me happy. What we had was a situation where the North Carolina Department of Justice, under the leadership of Attorney General Josh Stein, their lawyers came in to the State Board of Elections meeting, and they essentially told them that if you defend a certain set of laws, including the deadline for absentee ballots, pure process for absentee ballots, and several other things, if you took this to court, you would lose. This is despite the fact that states have won similar cases, that same year. And so under that guidance from the North Carolina Department of Justice, the State Board of Elections, the 5-member board, voted to settle with this particular case with Democratic Attorney Mark Elias. Once facts came to light, 2 of those members, the 2 Republican members, actually resigned from the board, had to be replaced later on. Attorneys from the legislature were there. They were intervening defendants in the case, but despite that, the judge in the case decided to cut them out of any kind of settlement talks. And so the State Board of Elections settled with Elias. They altered laws that were passed by the legislature for the 2020 election. And so we ended up with this situation that we had here. Interestingly, at least for internal to North Carolina cases, hopefully we fixed this, because it included in the last budget that was passed by the General Assembly with a veto-proof margin and so signed by the governor. They have a provision that says if the legislators are intervening defendants in a case, they have to be consulted or they have to approve of any settlements. That's on cases where they choose to intervene. So legislators don't have to intervene on a case, but if they do become intervening defendants, like they say, we don't really trust the Attorney General to defend this law, we'd rather do it ourselves, then they have to be included on any settlement. So this should hopefully be fixed at least at state level, and then we'll see how the Supreme Court deals with this at the federal level.
And in this case, there doesn't necessarily even have to be concern that the Attorney General is not going to defend the law adequately. If I remember correctly, one of the arguments in this particular case is the Attorney General is representing the interests of the State Board of Elections, which is really interested in just having some set rules that aren't going to change, whereas the legislative interest is defending the law itself. And that's one of the differences that the legislators are putting forward as a reason why legislators should be allowed to intervene to defend that interest, as the Attorney General is focusing on defending the interest of the State Board of Elections.
Yeah, indeed. There are lots of times, and we all know this, where the executive branch interests and the legislative branch interests are not the same. Certainly in North Carolina, where the governor might not like a lot of the laws that the legislature has passed over the past decade. And this is, once again, what we saw last time around. Some of those changes were changes that the executive director of the State Board of Elections tried to get. She had asked for them from the legislature when they passed this kind of coronavirus elections bipartisan bill. They gave her some of what she wanted. They didn't give her everything that she wanted. She also tried to get expanded emergency powers through a rules change process. That got shot down. A great thing we have in North Carolina is something called the Rules Review Commission. If your state doesn't have one, it should, where they basically, anytime an agency wants to change a regulation, now this goes to the Rules Review Commission. They don't address the policy. Is this a good idea or a bad idea? They just address, does this fit state law as passed by the legislature? And if it doesn't, and this request by the State Board of Elections did not, then they shoot it down and they can't implement it. And so this settlement became the third opportunity for the State Board of Elections, the executive director and the other leadership to get changes in the law that they wanted.
I want to bring in our panelists from the national groups that played a part in friend of the court briefs at the U.S. Supreme Court to talk about this issue as well. Jonathan brought it up in his opening remarks, but I want to give each of the other panelists a chance to leap in and chime in here. One of the issues here seems to be the fact that our General Assembly passed a law that said that if there's a case involving the state and challenging the constitutionality of a law, the General Assembly can jump in and play a part and help defend the law. And that, as Jonathan mentioned, it seems that the judge in the Fourth Circuit, Loretta Biggs, just basically ignored that state law. And that has to be of concern to anyone who's interested in the legislature playing its proper role in defending election laws. And I open that up to any of the panelists who wants to jump in.
Well, I certainly think that it's important that state legislatures do what North Carolina did and establish a right to intervene in these cases. It unquestionably makes it easier to get involved. And I hope that this case that has gone up to the U.S. Supreme Court will help to resolve this question once and for all. But a number of state legislatures, in part because of what we all saw in 2020 with the collusive litigation, have either been considering or passing legislation to create this right. So the state of Wisconsin has this, it actually had it before 2020, was able to successfully use it to prevent a court action that would have made significant changes to their election laws. In the last year or so, we've seen South Carolina adopt legislation that creates this right. We saw Idaho just a few weeks ago pass a measure that allows their legislature to intervene. There's a measure in Arizona which would do a similar thing, which is working its way through the process. This is across the nation recognized as a priority and a necessity, as long as we're going to live in this sue and settle world where courts are just an extension of the policymaking process and can step in and unilaterally undo something which the legislature has adopted. I think it's important that we make sure that lawmakers have that ability to protect their interest. As I've told people many times, you can go through the process, get the best possible voting laws, and they can be undone in an instant, sometimes behind closed doors in the course of collusive litigation that ends in a settlement or consent decree. And you have no idea what was actually negotiated in that process. You just wake up and your attorney general has unilaterally changed your laws.
And I think that the justices during oral argument seemed to almost assume that this was one of the things going on in the background here. They appeared to be very interested in what was going on behind the scenes. And I think that's going to be one of the reasons, and what happened with the litigation spearheaded by Mark Elias and others of his ilk, that's going to result and help result in a win in this case. And I think we will win the case. My reading from courthouse observers of the justices, and also my view of who was asking questions and the kinds of questions that they were asking, is that there's going to be a significant win in this case.
I have to agree with that. And in fact, if I recall correctly, it was Justice Breyer who actually at one point said, this is an elections case. It seems like the legislature has a pretty significant interest here. And I think that's a good omen. And at another point, Chief Justice Roberts asked the attorney representing the NAACP, aren't you asking us to pick who you're going to be arguing against? What are you afraid of in having the legislature come in? Which I take it as also a good sign here. And perhaps we can take a few moments later on. I don't know if Jonathan has any more on this point, but we've mentioned Mark Elias a few times, and I'm not sure if he's come up on other of your programs, but I think it would be worth a few minutes to talk about who he is and what his operation is, because it gets really to the heart of this issue. There is a concerted, extremely well-funded national effort to use courts to change election laws, and I think that's certainly part of this, backdrop here that we should take a moment to talk about.
We certainly can get into Mark Elias, who has been at least part of discussions previously in the Shaftesbury Society because of his direct role in some things happening in North Carolina. Before we move away from this point, though, Jonathan Howard-Schultz, you were the first one to bring up this point, so anything else you wanted to add about the federal court seeming to ignore something that was actually passed by the legislature that would allow these legislative leaders to intervene?
Yeah, and just a couple of points. In some respects, the Supreme Court here is going to be resolving a circuit split because you have the Fourth Circuit and I believe the 11th Circuit that basically have, for purposes of intervention, chosen to largely ignore state law. But then you have the Sixth Circuit, which is where Wisconsin's located, and others that give full force and effect to state law. So that's why you saw in Wisconsin the legislature effectively able to intervene. So the court does have to kind of reconcile that. But I will echo a lot of what Thomas and Jason have already said. My reading of the transcript is largely positive. There were a lot of questions, and even again, it may have been Chief Justice Roberts, may have been Breyer, I can't remember which, that talked about not just what lawyers refer to as venue and forum shopping, but actually shopping for your defendants. Because they raised the point that in North Carolina, the North Carolina courts have to give effect to state law and give the legislature the opportunity to intervene. Or they can choose federal court, where again, in the Fourth Circuit, they have chosen to designate essentially the Attorney General as the proper party, the courts have, and ignoring the state law. So it's really interesting, some of this stuff that the Supreme Court has to kind of decide in this particular case. And let's just say I don't envy the justices in trying to balance some of these interests and deciding what the outcome should be.
All right, we're going to touch on that point of Mark Elias coming up in just a bit, but all of you at this point have now referenced the actual oral arguments that took place. Now it's been a couple of weeks ago, and what was asked, sort of the tenor of the questions coming from the justices. Don't want to put you too much on the spot, but if you had to predict the type of ruling that's going to come out, I'd like to get from each of you what you think is sort of the most likely outcome. We know that the Supreme Court likes to rule as narrowly as possible under Chief Justice Roberts when it can. Are we going to see something that will be very narrow that focuses only on the North Carolina case, or might we see something that will have a larger impact on any state legislator that's trying to defend its interests in being involved in an election-related suit? Anyone could jump in.
Well, I think that it's going to be a decision and an opinion fashioned to election law, and particularly the interests of the legislature. Because I think that from a historical point of view, from a point of view of the Supreme Court's desire to limit the focus of its opinions and the rules that it pronounces, I think it would sort of mirror what Justice Breyer said. Wait a second, this is he said, this is an election law in all caps case. And I think that's how it's going to come out. And I think it's going to come out surprisingly. I believe that Justice Sotomayor will probably join with Justice Breyer in ruling for us.
Thoughts from either Jason or Jonathan about what we might see in a final ruling?
Well, I tend to agree. You can always hope for the best. Maybe we'll get a unanimous opinion on this, but I don't know if we will. Nevertheless, I do tend to agree. One thing that I'm hoping to see, though, is some discussion of the elections clause and perhaps some clarification on whether or not that is indeed the law of the land. That would go a long way, I think, towards resolving some of these disputes and disagreements, and also potentially cabin some of the other abuses that we've seen in a litigation context in particular. But I do tend to agree that that's the sort of opinion that we'll see, and then I'll keep my fingers crossed on the rest.
Jonathan?
Yeah, as I know Thomas and Jason are longtime observers of the Supreme Court. I've learned not to prognosticate. The tea leaves can go both directions. Instead, what I like to do is to sit out and say what I'd like to see, and then based off of past court precedent, what we're likely to see. And of course, what I would like to see is exactly what Jason said: a large, broad brushstroke decision opining on Article 1, Section 4, the role of the state legislatures, and emphasizing the ability of the state legislators both to set election law as well as to defend it. I think under the Roberts courts, it's more likely that they will issue a narrow decision. If we look at their history, especially in election law, it's a narrow decision that they then use what lawyers call a shadow docket for broader purposes. And so I think what you're going to see is a narrow ruling that says, hey, if a state law has this provision that allows the state legislator to intervene, then the court needs to do this type of analysis under Federal Rule Civil Procedure 24, and then send it back to the court, the lower court, to make that decision, but a strong inference that the legislature has standing. I had some questions, some concerns over some of the questions asked. I think it was Sotomayor that basically said, hey, if this law is allowed to stand and we look at state law, can't a state pass a law that would give every single legislator in a state the right to intervene? And the answer was, no, that's not what this law says, et cetera. But there was at least that objection raised, which makes me think that the more narrow opinion is more likely, and is more likely to get even someone like Breyer or even Sotomayor on it as well.
Well, we won't hold any of you to any of these predictions if they don't come true. I was putting you all on the spot. Thank you for playing along. As we get closer to 1 o'clock, I do want to remind folks that if you do have a question for any of our panelists, please feel free to submit it via our Facebook page, facebook.com/John Locke Foundation. We may have some time for a couple of those questions. But I do want to loop back to something that came up a few minutes ago, when it was Jason Sneed of the Honest Elections Project who suggested that we spend a little time talking about Mark Elias and his role in the elections process and why that might be something that's relevant to this case. Before I turn it back to Jason to delve into that, I want to bring in my colleague again, Dr. Andy Jackson, because he has written on a number of occasions about the role that Mark Elias has played in North Carolina elections. Andy, give us your thumbnail discussion of Mark Elias and the role that he has played in recent years in North Carolina.
Mark Elias has been, I wouldn't say ever present because he parachutes, all over the country, but he's been a pretty constant presence in North Carolina, election law, lawsuits. As observers in North Carolina may remember, he was representing Dan McCready in the dispute over whether or not the State Board of Elections should certify the 9th Congressional District race in 2018, where he was essentially trying to get that result overturned based on ballot harvesting. And lo and behold, he is actually also an advocate for that very same thing. He would like to see it legalized in states like North Carolina. He has an active lawsuit that's maybe on the back burner at this point, but it could come up again at any point, trying to overturn North Carolina's law that prohibits ballot harvesting or ballot trafficking, if you will. And so he's more or less a constant presence, mainly because he has enough money to do so. There's a constant flow of funds going in. He set up his own practice, got a bushel full of attorneys to work with him on this. And so it's kind of like the United States strategy in World War II. They have enough funded that they can kind of push everywhere all the time. And it kind of puts their opponents on the back foot a lot of times, just because you just don't have those kind of resources to do battle with them. And so we're certainly not going to see the last of him and his associates here in North Carolina. I mean, obviously, they're not the only ones. We have our own crop of litigants that are going to sue about something or another every year in North Carolina. But the fact that he can bring those kind of resources to bear means that oftentimes, if there's a big issue, just like our latest redistricting case, he or his associates will be there.
Jason Sneed of the Honest Elections Project, you were the one who brought up Mark Elias's name and thought we should spend some time talking about him. What should this audience know beyond what Andy has just told us about Mark Elias and what he's up to?
But well, Andy's summary is spot on. He really is involved in very high level planning and strategy. He's sort of got a hand in every cookie jar, if you will. He's incredibly well connected within the Democratic Party. He used to be at a law firm, Perkins Coie, and while he was there, I think that he and his practice were responsible for representing virtually every elected Democrat at the national level, as well as the DNC and the DCCC, DSCC, Priorities USA, the big left-wing super PAC. So he's incredibly well connected. And when he broke away from that firm and started his own Elias Law Group, it was a heck of a big bushel of attorneys that he brought with him. He started a law firm on day one with 60 attorneys, including 15 partners. So that gives you a sense. I mean, just think about the payroll alone. But he is active in a number of states, and in 2020, his strategy was to be as active as possible in places like Arizona, Georgia, North Carolina, Pennsylvania, Michigan, Wisconsin, Minnesota. Now, I'm sure that it's just coincidental that if you hold the map where he was particularly litigious up against a map that also happened to be presidential battleground states, that there's a perfect overlapping in the Venn diagram. I'm sure that's just coincidental. But he really took advantage of COVID to create new opportunities to file litigation to try to undo election safeguards, voter identification laws, requirements that you receive absentee ballots by election day if they're going to be counted, all of these sorts of things. And it was a very national coordinated strategy. And some of his biggest successes and his most enduring successes were what was delivered in North Carolina, victory by consent decree or settlement. When he was actually challenged and opposed, he was very often defeated. And so this memo, this guidance that was issued that you can't go against him, you will lose, is, I think, a perfect indicator of his preferred strategy. He prefers to win without actually having to have the fight and then get everything that you want when the party that you're suing simply agrees to fold and deliver everything that you want, because they also want it too. And that's why this case in particular is so important, because there are a lot of other legislatures that are looking to the Supreme Court for guidance on whether these sorts of laws are acceptable, permissible, constitutional. And they're under the gun because of this litigation strategy, which is a 50-state national litigation strategy. And so that's why this is so important. And I just wanted to take a moment so that folks understood Elias's reach and his strategy, and truly the crucial nature of this particular lawsuit for setting the stage for other states to follow North Carolina's example and make sure that their lawmakers can actually defend their interest in the lawmaking process.
Tom or Jonathan, either of you have some thoughts about the Mark Elias influence? And if not, we can move on to a question, but I'm happy to have either of you or both of you comment on it.
Yeah, I just a short comment. The great thing about the Mark Elias phenomenon is that it's a phenomenon. And virtually every election lawyer in the country knows what the strategy is with regard to Mark Elias. And judges know, and legislators know, and politicians know. So we are now on notice. And the Lawyers Democracy Fund, one of the great things that we're involved with the scholars on our staff, is pushing out articles and research in connection with professionalism, ethics, and honesty in connection with election law. So I think that Mark is helping us get people energized.
Yeah, a nice face and name to put out there to get people focused on the task at hand. Jonathan, any thoughts on Mark Elias before we move on? If not, I'm happy to move to a question that we have from our Facebook page.
I'll be really brief and to kind of emphasize what Jason said. You know, when parties, states, state legislators, individuals push back against Mark Elias and actually force him into court, Mark Elias has a losing record. You know, he pushed too far in Arizona with Brnovich. He pushed too far in Wisconsin. It's as long as the cases actually get to the appellate level, he tends to lose. So that's just an encouragement there for those involved in election integrity to make sure he gets to the make sure they take the fight to him.
All right, I am going to get to a question from our Facebook page. Thank you to all the panelists for weighing in on that. Kenneth asks, could the Supreme Court of the United States say this is a state legislative question and send it back without a decision? This non-lawyer thinks that they probably won't do anything without a decision since they've actually gone through the whole formal process, had the oral arguments, but I want to turn it over to the experts. Is this possible? Will the Supreme Court say this is a state legislative issue, we're not going to do anything about it?
My answer is no.
Short and sweet.
Right.
All right, well, that's
agreed.
Unless anyone has any other thoughts, I think we're getting to the point in the program where it's time for me to give everyone an opportunity to give your final thoughts of where this case stands and why it's so important for the decision to come out in favor of the General Assembly. Let's go in reverse order of the way that I started it. And so let's go to Jonathan Howenschulte of the American Legislative Exchange Council. Jonathan, why is this case so important, and why is the result in favor of the General Assembly so important?
It really goes down to what is the effect of state law. You know, can a state legislature make a determination about the best party to represent itself in court? And if the Supreme Court would ignore the state law, then what other state laws can they ignore, especially on the process and the procedure? And what effectively it does is it would promote the judgment of a court about the best party above the state legislature. It would elevate a court's analysis of civil procedure rules on the federal level above state law. And then you have the cascading question. If you're going to do that, if you're going to ignore state law on one provision, what other provisions are you going to ignore state law on? Where else can you find rules of civil procedure to overcome state law? Where else can you find judicial analysis to overcome state law? And just basically completely ignore the role of the state legislature.
Tom Spencer of the Lawyers Democracy Fund, you are very confident in a win at the Supreme Court this time around. Why is it so important that this case come out the way that you hope it does in favor of legislators?
I think because the position of the legislature in our society, our political society, needs to be energized and emphasized. And I'm hoping that in the opinion here, the court reflects upon the history of the place of the legislature in our system, and the fact that it is in our Constitution, Article 1, demonstrates how important its political position is, and it has been pushed down by the tremendous growth in the power of the executive branches throughout the states, such to extent that, like in this case, the Attorney General could both run on a platform against voter ID and then claim that he is a honest broker in connection with advancing the constitutionality of the same statute. So I'm very optimistic that we're going to get something that we can all celebrate.
Jason Sneed of the Honest Elections Project, your take on why this is such an important case and why the result should come out in favor of the legislators.
I agree with everything that Tom and Jonathan just said. So I'll add one more reason here. And it's more of a general election related reason. We are at a unique moment in our history where increasingly on the left and the right, we can't agree on what the rules of election should be. We can't agree that an election is inherently fair. We are losing voter confidence, and the shoe can easily be on the left or the right, depending on the outcome of an election. I think it is crucial that we have election rules that are established through a transparent legislative process, that those rules are honored all the way through an election, so that no matter what, both sides can say, at least it was fair, at least we followed the rules. And right now, what we are seeing increasingly is not so different from the umpire in a baseball game changing the rules for balls and strikes in the seventh inning because he likes the home team and they're losing right now. And that is a recipe for disaster and loss of voter confidence, and ultimately, a loss of voter willingness to trust the legitimacy of the democratic process. So I think as a first principle, we should be elevating legislatures, making sure they set the rules, can at least defend them in court when they are challenged, and hopefully get back towards a system where we have election rules that are as was said earlier, make it easy to vote and hard to cheat, and that we respect from start to finish.
This is the John Locke Foundation, so I'm going to reserve the final word to our John Locke Foundation panelists, my colleague, Dr. Andy Jackson. Andy, what do you hope to see out of this case, and why is it so important?
Well, I agree with all the other panelists. We certainly hope to see that the Supreme Court's going to rule that in favor of allowing the legislature to defend the law that they passed. I think this is a fundamental separation of powers issue. It is the place of the legislature to pass laws. If you allow collusive lawsuit settlements with the executive branch, you essentially give them the means to change laws, to alter laws. Now, this doesn't take away any of the powers of judicial review, executive actions. All this is a pretty narrow case, really, in that if the legislature doesn't believe that they're going to adequately be defended, that the laws they passed will adequately be defended by the executive branch, in this case, the Attorney General, that they have the ability, the power to defend that law themselves. And I think ruling in favor of the General Assembly will help reestablish and affirm that power.
That is Dr. Andy Jackson, director of the Civitas Center for Public Integrity at the John Locke Foundation. You also heard from Jason Sneed of the Honest Elections Project, Tom Spencer of the Lawyers Democracy Fund, and Jonathan Howensschuldt of the American Legislative Exchange Council, ALEC. Thank you to all of our panelists for the excellent presentations. We thank you for watching at the John Locke Foundation's Shaftesbury page. We love doing these events for you. And if you like what we do with the Shaftesbury Society, please go to johnlocke.org, find the donate button and support us. And also a reminder, there will be no Shaftesbury Society meeting 1 week from today. 2 weeks from today, on April 18th, we will resume the in-person Shaftesbury. So and if you do watch online, you can continue to watch online because that in-person presentation will be streamed. Thanks so much and enjoy the rest of your afternoon.